You're listening to the Valley Current.
So Linyan, tell us what happened with jury duty.
So I sent you the pictures. So basically, we went into the courthouse and there was a big room and there were a lot of people there. So about, I would say 50 people in one room. And they had us watch a little video as an introduction. The video basically just talked about the basic components of a trial. So they went over like what an opening statement is, what a closing statement is, what objections are, etc. And there was a little part in the video where the former Chief Justice of California, Tani, I forgot her last name, but she talked about how as an attorney, she actually served on juries before, which I thought was interesting. So she just talked about why it's important to serve on a jury. And yeah, so then Judge Amy, I forgot her last name. I can look it up again. Sadak. She came in to talk to us. So they gave us our receipts that we need to show that proof that we were there. Then she talked to us about exceptions, so hardship exceptions, like, for example, if it's a really big financial burden, then that's a hardship exception. Or if you're a student, a full-time student, that's a hardship exception. And so to go up to her department and just line up in front of her door if you have a hardship exception. Then she talked about us, for the rest of us who don't have hardship exceptions, we need to fill out a questionnaire. And it was a super long questionnaire, about 16 pages.
And it's all printed out. It's not done with an iPad or anything like that?
No, it was all printed out. It was a stapled packet, just all paper. She said, so we have to fill that out and turn it in. And if they go over it and they decide to call you in, then we have to come back Monday.
So this is like a preliminary screening.
Yes. Yeah.
So
yeah.
You report.
Yeah, that's interesting. I wonder if they've changed it like statewide and they do that now, or if that's because you're in that particular court.
Yeah. Did you know if you were in criminal or civil, or did they tell you?
Criminal. They told us what the case was about. So she mentioned this because she said if some people have like trauma with it, then they can opt out, or they can talk to her about it. Basically, she said it's a criminal case where the defendant is accused of molesting 2 children between 7 and 13. So she said, if you have trauma related to this, or, if you were a victim yourself, you can go in private to talk to her if you want to opt out of it.
So this was for a very particular case? That's weird. It wasn't for all the court, like all their cases?
Yeah,
no.
It's surprising to have. If I'm watching this screen that you sent, we can play the video, 10 seconds of video. It looks like it's like 100 people there. Look, 10 plus rows of 10 plus people, maybe 150.
Oh yeah, 150. Yeah.
That would be like for the whole courthouse, I would think, not like one case.
Well, unless you say somehow what's going to happen is that they're going to have some percentage that have hardship exclusions. Maybe a pretty big percentage.
There was a huge line there about, I would say, when she said, okay, if you have a hardship exception, come up to my department, about half of the room left.
Right. So think about that just from an educational point of view. when you have a jury case, even a criminal case, where you're supposed to be judged by your peers and a fair cross-section of them, you're going to lose like 50% plus of what might be called the full-time employed people who are probably younger, maybe arguably smarter, and who are sort of dodging service or otherwise putting other priorities in. And that means that 150 is going to get reduced to maybe 75. And of those,
well, maybe it's because the case too was this case sounds like it's going to be a while, as opposed to usually when you get on a jury, it's like maybe a week for.
What did they tell you, Linyan, was the likely duration?
They said about 4 weeks. So.
Wow. So did you claim a hardship, or what did you say?
I didn't really have a hardship I could claim. So I basically just, in the questionnaire, I just basically tried to put as many red flags, I guess, as I could. So
not having you for 4 weeks would be a total hardship for a small firm. That's for sure.
Right.
It's not like we're 200 or 100 or even, more than a handful of people. So I think the judge will understand that. I mean, usually that's the second point, which is a long criminal case and one that is in a subject matter that no one's really going to like, is inevitably going to result in a lot of hardship requests beyond full-time employment. I don't get paid for it. It's a hassle, whatever. I mean, there's going to be other such requests. So that 75 that might be left might get reduced to 25. And then of those 25, they're trying to seat 12 and probably maybe as many as 2 to 4 alternates, depending on, 4-week trial. They're going to probably lose a couple of people who can get sick and so on along the way. And remember, a defendant can declare a mistrial, criminal defendant, if there's less than 12 jurors. So the judge is probably anticipating at least 4, maybe even 6 alternates. So there's going to be 18 people that are going to be together for 4 weeks, because an alternate may even have to serve if someone gets sick during deliberations. So it's really, you have to use big numbers. I mean, look at the production cost of this criminal case. People ask why plea agreements get entered. I don't think the system could operate without plea agreements, just like I don't think the system can operate without settlement agreements on the civil side, because there's just too much cost. I mean, look, I don't know what they pay. What is it, like $15 as a daily jury fee?
Yeah, $15. But the first day, so yesterday, they didn't pay us. They say you only get paid after the first day. So it's $15.
So it's like a freebie for you to spend whatever number of hours yesterday going down to the courthouse, filling out the questionnaire, listening to the instructions, waiting for whatever process to occur. And then you're effectively now on call for presumably all of next week, right? That they could call you in, or they say you'll know by Sunday or Saturday or Friday whether you have to show up on Monday.
They said to keep checking every day after 5. And so I would check Sunday also to see.
It's quite a big production. And I imagine the folks that are left over will probably mostly be retired people, mostly be people that have nothing else that they're really wanting to do with their time, or that they have to do with their time.
Or the state employees. I think like my mom, like she didn't work for the state, but she worked for like a state, like she worked for University of California, like purchasing or whatever for the hospital up at Davis. And she had to serve on one, but it's like I guess they get paid, or I don't know, like it's not a big deal. And they want like as many people, like that's why they look for those people, especially if you've got a long jury, a long time trial.
Mm-hmm. Yeah, 4-week trial. It's almost like the defendant must, or is it one defendant or 2 defendants?
One defendant.
Hold on, so let's play this one. This is another one you sent, which I'll see if I can bring up.
Oh, this was when less people were, or yeah.
People have shuffled out, so you have like maybe 75 left at this point.
This was earlier, so.
As people were coming in.
Yeah, people were coming in.
People were coming in, yeah. So you're in that courthouse that does both criminal and civil, right?
Yes.
And
yeah, maybe she was chosen for the specific criminal. Maybe there was a grouping of them chosen for that case, and then maybe there were more people in there for like what I'm used to, like the smaller cases that are happening that day.
Yeah, the notice that you showed us the last time was what was there, like 15 different groups, something like that? You were a certain group number 10 or something like that?
They said groups 1 through 170.
1 through 170. Okay. Wow.
Yeah.
Right. And you were in group 10, which I assume is maybe just this one group. Might be group number 10 on the view that maybe this is just the 10th in-person jury trial. I mean, it's hard to believe that there wouldn't be more than that on the criminal side. What 170 is referring to, right?
Yeah. Okay. So I can look. Okay. So it says group numbers 37 through 54 report to Dublin, East County Hall of Justice. The groups 55 through 67 report to Oakland. Group 68 through 170, you're not needed at this time. That's what they say right now.
Okay, so this is like for the entire county. So you were in group 10, which was reporting to, where's that courthouse?
Dublin.
Dublin?
Dublin, yes.
I thought Dublin was 37 through 54. Didn't you just say Dublin was 37 to 54 and Oakland was 55 to 67 and 68 and 70? So what is the rest of the group? It sounds like they group off at roughly 12. I'm just looking at the numbers.
Oh, they said, so, okay, this was just updated. So they said groups already used this week, groups number 1 through 21 were at Dublin. So on the 2nd. So that was yesterday.
Oh, so you went to Dublin yesterday?
Yes, Dublin yesterday. And so yesterday in that room were groups 1 through 21.
Okay, so 1 through 21 probably comprised north of 150 people. I'm just reversing.
They weren't all for that one case, right?
I not too sure, but I would think so, just because they said groups, when they told us to report, they said groups number 1 through 21 report to the Dublin East Hall of County of Justice at 8:30 a.m. And
how far away was that?
But did you ever get separated, or was like all of them all in there the whole time? They didn't go to any other cases? We were all in there the whole time. From the very beginning, they said, if you're here for jury service, report to this room. And they just shuffled us into the room. So they only had that one case that they knew was going.
Yeah. Yeah.
And you really, like, if you look at, you have to go through, you have to get there, you have to park. I guess they give you free parking with a pass or something. They do that much?
No pass, but it's free parking.
And you drive how far from where you live to Dublin?
Oh, it's super close. It's like 10 minutes.
And you get there by what time?
It started at 8:30. I got there 8:15.
And you got to go through security, right?
Yes.
And you're done by what, 11?
No, about 12.
Okay, so they basically take a half day of your time for free to qualify you and to go through the rigmarole of, are you going to claim a hardship? And are you going to fill out this lengthy questionnaire that probably had a lot of interesting data on it? Would have been interesting for you to take some pictures of each page. I don't know if that's legit or not, but I'm guessing that was constructed for this specific case where they asked questions about, have you ever been molested, that sort of thing?
Yes, so they said technically you're not allowed to discuss the questionnaire. So I don't know how strictly they enforce that.
You can't take pictures of it, even though maybe it's a public document, maybe it isn't. I guess you'd have to have the case number. Does the document actually have the case number on it?
Yeah, it does. So I think I should be able to share that, right?
Yeah. So why don't you show us the case number or whatever you have? I'll stop sharing and you can.
Yeah, they didn't. They didn't say that pictures were not allowed, so I just took them for private use.
I think it's just educational for us, so it's all okay. But in general, to me, there's a lot of value at looking at how much of a process exists and why judges are so reluctant to allow jury trials. Like they do everything possible to screen cases as, unworthy to justify the amount of time and to force settlements, to try to get settlements or plea agreements to be entered. So do you have the actual case number and we're able to look up the case, or they say, no, you shouldn't look up the case?
They said when you're on the jury, you shouldn't look up the case.
You're not on the jury yet, right?
Yeah, I'm not on the jury yet, so I looked it up, but I couldn't find really anything about it. The case number is 20. I can put it in the chat.
Put it in the chat. But you're saying you didn't actually go to the courthouse web docketing system to see what you could find out about the case.
It does answer a question I always wondered, though, was because it makes such a big difference if you're going to serve on like a long jury. Like when I was sitting there, I didn't get chosen to go into any jury or jury selection. I just sat in that room that she was showing, waiting to get called, right? But I never got called. But they were all small cases, I was presuming. But I was sitting there going, what if it's like a long thing? Because then I would have to claim a hardship. Like that's the difference. Like if it's a week, sure. If it's 4 weeks, no. But I guess they tell you, they warn you.
Yeah, I mean, to me, they've got to give you some indication so you can let your boss know, well, what's really going to happen here, because it affects a lot of people in a lot of different ways, right? I mean, it's not trivial. Like it's not a trivial situation.
Yeah.
So this guy's name is Nelvin Aradaza. And when you search, at least using just a simple Google search, I don't know if you've done that, if you've done such a Google search at all. It doesn't come up with anything, does it?
It doesn't come up with anything, but I'll try to look on the court website.
Yeah, I mean, it's a criminal case from 2020, so it's been around for a while, right? Because we're in 2023, right? So it was filed in 2020. And, I'm guessing it's been through a few cycles towards settlement.
I didn't know you could even have a criminal case that long, because isn't it something where the person would be sitting in jail?
Well, unless he posted bail, right? I mean, if you posted bail, he's out on bail. It's a little bit like Elizabeth Holmes, right? She's posted bail. She's still out on bail. She's got a pending request to the Ninth Circuit to supersede Judge Davila's decision that she was to go to jail for what is like 135 months or something like that. Her co-defendant is actually reported to jail. And so you didn't even try to make what I'll call this Hail Mary to the Ninth Circuit that she's making, where she's saying, look, I think there's such significant issues raised on appeal that you should allow me to basically be out pending the appeal. This is, to me, it's just pretty rare to imagine that this is going to succeed. But I don't see any case information about this guy, Nelvin Arizada, right? I mean, the fact that they give you the name suggests that you can obviously easily look him, if it's a him or her, up. I'm guessing it's a him, right?
Yeah, him. Yeah.
Yeah, I'm not sure. It's not for criminal stuff until it's the actual trial or whatever. Isn't a lot of that kept under seal?
Yeah, sometimes. I mean, there's a guy on LinkedIn named Nelvin how you pronounce his last name, who's a 4-man at Black Creek Builders, and says he's been that from September 2008 to present. Maybe he's the accused. I don't know. In Hayward, California.
Same area?
Hayward, California is nearby, right?
Yeah.
Yeah.
So I don't know if that's him. He's the only one on LinkedIn. I mean, obviously, maybe him, maybe somebody else. Who knows? But this is the world of the internet, and so you can get a lot of information just doing a search of name. But when you go to the actual court site, Linyan, does it bring up the actual docket sheet for the case?
I have to register for it. So
Yeah, you probably don't want to do that. You probably don't want, because then they'll raise questions about, well, you looked at stuff, maybe you shouldn't have. I don't know. I mean, I thought there was a way for the public to see more information about it, but it doesn't sound like there is. Doesn't sound like there's an easy way to actually see that docket. Like,
That may be why they didn't mind disclosing that. Maybe they wouldn't have disclosed so much information up front if they knew you could get stuff.
well, the questionnaires say, do you know this defendant? Do you know any relatives of this defendant? Does the questionnaire get into that level of detail?
Yes, at the end, they didn't ask about the defendant, but they had a whole list of witnesses, names, and they said, tell us if you recognize or you know any of these witnesses. But they didn't ask about the defendant himself.
So the long list of names was witness names, that sort of thing?
Yes. Yeah.
And so it was like a number of names you'd never seen before. I mean, had you said that you knew anyone, that would have been kind of an immediate grounds for recusal. And sometimes that happens. I mean, we did a jury case where literally one of the jurors said, "Oh yeah, you sued my husband, Mr. Russo." It was like who I didn't even remember the case. It was interesting. It was like such a shocking statement, and the judge.
Wait, you mean that actually happened to you?
Yeah, I was picking a jury, and the judge said to the jurors that were, at that point being subject to voir dire, let me start with some general questions. Does anyone know the plaintiff? I was representing this company called Data Trend. It was in the San Mateo Superior Court. And they said, no. Does anyone know his counsel, Jack Russo? And a woman stood up and said, yes, I know Mr. Russo. And I looked at her like, I don't know who this is. And I wondered in the back of my mind, are they just seeking to get off the jury? And they said, well, how do you know Mr. Russo? I said, well, I don't know him personally, but he sued my husband. And then she announced the name of her husband. And I nodded and said, yeah, I guess that was a case many years ago. And they just said, well, thank you.
Oh, so you didn't sue the husband. You were the attorney.
I was representing a company that sued the husband or defended a lawsuit by the husband. I think we had actually sued. I think it was a trade secret case, and he was one of the individual defendants. And she said, oh, Mr. Russo is very professional. She said something very nice about me. I remember that. And it just was, that's very good. Yes, you don't have to serve. Thank you very much. That was it. It's like, well, she's either going to be prejudiced. She's either going to be prejudiced in your favor, or she's going to be prejudiced against you. And in either case, we're not getting a neutral juror. So thank you very much. She's gone. And so that, that's a way out. Obviously, I couldn't absolutely verify that she was in fact the wife or still the wife of this guy. And I barely remember the guy.
Well, how in the world would she know just to say that? I mean, she knew the kid. I mean,
yeah, maybe.
Pretty much presumed at that point.
Yeah, maybe. I mean, I didn't question it at the time, but now that I think about it, it wouldn't be hard if you're sitting on a jury and you want to get out, and so far you haven't gotten out, to just say, well, I think let's pretend Fenwick and West, because that was my old law firm, was sending some associate to try a case. It wouldn't be hard to say, oh yeah, there was a lawyer from Fenwick and West that sued one of the companies I invested in. And I forget the name of the company and I forget the lawyer, but it was from the same firm that Mr. Jones, who represents, whoever plaintiff or defendant is at. That would be an easy way to get out. I mean, I'm not saying anyone should do it, but I've seen people use many different techniques. I saw a guy who said, well, Your Honor, you really don't want me on your jury. And the judge said, why? Well, I have a prostate issue and I'd be needing to go to the bathroom every 20 minutes. And that would be very disruptive. And the judge said, okay, fine, you're out. Like, basically, who's going to verify that? I mean, the guy was a bit.
Well, it's not really about verifying. I mean, at some point, yeah, you just have to take people at their word. Yeah, it might be a lie, but
I'm just saying, there's a lot of ways out. There's a lot of ways to get out. I mean, obviously, the most straightforward way is the one the court gave right at the very beginning here for, hey, what kind of hardship exemption are you going to make? And then there's some other administrator that presumably is processing that, right? That's the whole group of people that stood up that you showed, right, Linyan?
Yeah.
And that's why the old Chief Justice, I think probably that's why they have her sitting there talking about the importance, because they know people can, they know that everyone can have a reason not to. They have to give people a reason why they should stay, Well, yeah. So I think that's why they showed that little whatever thing that she was talking about.
The economics are upside down because it is arguably a form of involuntary servitude. We have a 13th Amendment. You're being called sort of against your will. No one is really volunteering the way you could say, well, you could volunteer on your ballot box voting card. You can say, I volunteer for jury service, I guess, if they could want to be able to trace that, you could fill in a separate card. No one really volunteers for jury service, right? So you're being involuntarily compelled to provide essentially judging services. You're judging.
But you have to know why that is. It's because if you're on the other side, this is to make our system fair, and to make our system fair and to protect against, injustice. We've had this jury trial, and it's the only way it works. So I guess you have to explain that to people to maybe make them want to stay.
Right, but I'm making the bigger point, which is no one has asserted, to the best of my knowledge, and maybe they have and they've lost, that there's a 13th Amendment to the U.S. Constitution violation of involuntary servitude to serve as a juror against your will. So maybe you could argue the reason that kind of claim wouldn't succeed is because there's this exemption process. And you're allowed to say, I'm a conscientious objector to judging anyone. And there are some people that, from a religious point of view, probably would say, I don't feel as though it's my place to judge anyone, and I'm not going to do it. Just like there are people who say, I can't possibly ever vote for the death penalty. And those people are excluded because they're
for obvious reasons.
Right. So my point is that this is like an interesting question, because the courts kind of make the assumption that the jury system is working fine. And from my perspective, it's questionable whether it's working fine, because the truth is most people don't want to serve. Most people are there against their will. Most people dislike how long it takes. It definitely doesn't pay very well. I mean, $15 a day for even a 7-hour day is $2.10 an hour, or $2.05 an hour. It's not very much money, $2.12 an hour. I mean,
it is a difficult system, but the best way I think to look at it is, if you're on the other side, if you get charged with some sort of crime, and you want a jury, we could have a system that doesn't have juries, and then you never have to be burdened by that. But then, you're at the whim of whatever judge, and judges can be bought off, all sorts of things, especially if you don't have juries. So, I guess going back to that, it's like, if you're on that other side, you're going to want the jury. So you should probably serve on a jury when you're called to do it.
Yeah, I mean, we all learn that, but I just wonder, to what degree can you look at jury service as something that is some form of forced labor? Like, I just wonder that question, right? I'm looking it up very quickly. It says the Supreme Court has long held that involuntary servitude does not cover jury service. I never read that case.
Because you can't do involuntary servitude when it's something called upon by our country, I think. Because you can actually be willed to go to war even. Isn't that like the draft or whatever?
Yeah, right. That's right. I mean, it's the same thing, right? It's like, at some level you'd say, well, there's a Seventh Amendment right to have a jury, and
it's just for private. I think involuntary servitude has to be to private person.
Private as opposed to government?
Yeah, I think so. I think that that's what they would say. That the involuntary servitude, which is something that came along later, right? That was sort of like trying to abolish slavery.
Yeah, it says the Supreme Court has long held that, quote, involuntary servitude prohibited by the 13th Amendment was intended to extend, quote, to cover those forms of compulsory labor akin to African slavery, which in practical operation would tend to produce.
So it's intended to be to a private party. That's what involuntary servitude is. It doesn't extend to what the government might.
No, that's not correct either, because it cites cases that say the government can't compel certain activities. So it's actually more. I'll put the information in the chat. So it's more complicated than just the private versus public distinction that you're drawing. It's saying,
I think you might have to look at those cases and see, because I would think that, especially because the involuntary servitude came later and it was clearly done to abolish. I mean, that's kind of where it came from. Yeah, I wouldn't have thought that the government would ever allow it to be deemed to it. But yeah, I guess you're saying it has.
Well, so somewhere in this, you get to this question of, if it was a very long trial, as sometimes happens in these murder cases, can it become a form of involuntary servitude, right? Because there are some people that would claim that at some level. Like, I thought the OJ case, that trial went on for like 5 months, didn't it? That OJ case went on for a really long period of time, and a lot of people exited that jury pool, and they had to use a lot of alternates during that period, right?
And that's probably why they take on so many with a case that, it's like, it's estimated to be 4 weeks, but what do they really allot to it? Maybe they double that time as a potential.
Right. So what was your overall impression, Linyan, from this process? Did you feel it was done effectively, efficiently? I mean, to me, it sounds like it could have all been done online, but they've
Yeah, that's I don't know why they had to show up in person. I thought this could have all just be done online first. And so
You can't make sure people do it though if you do it online.
yeah, I guess. I just feel like, well, okay, I see that point. I just thought at least the packets, like they could have, the questionnaire, they could have had it done online.
Yeah, they're worried about losing control of it, right? That's what it sounds like.
Yeah, I think so. I think that one, you obviously the stuff like having you watch the thing that they want you to watch and all that stuff, they can't make sure that people would actually do it if they don't call you in. And to some extent, they want to see who's going to show up and that they can show up and that they are going to show up. That's sort of a test right there. And then on top of that, if they just say, hey, the rest of this can be done online, just make sure you fill this out. We need it by the end of day. Then people just leave and they don't do it.
Yeah, did they ask you, Linyan, your age as well?
Yes. Yeah.
And so they do that by asking your date of birth or
date of birth. They ask just general questions like where you live, your work.
Mm-hmm.
They
ask who you live with?
Yes, who you live with.
Mm-hmm. Okay.
Yeah.
So it's an interesting process, and I think it's not a lot of people report on it, and it's sort of a black box, and yet it's a big part of the system. And to my way of thinking, it's really something that will need to be improved in the next number of years, because I think a lot of younger people don't particularly care for jury service. Thanks, Linyan, for reporting on this.
Okay. Yeah.
Tune in next time on the Valley Current.